lucky overnight. Jackpot when I got the invite. Let me wrap my arms around you, cause I can't go home without you. And my heart just vibe with you, babe. Wanna go sky high with you, babe. Gotta bring you close to tell you that you're my lucky strike. And I got to tell you, if you didn't know, then I got to tell you that you're my lucky strike. And I got to tell you, if you didn't know, then I got to tell you, you're my lucky strike. Cooler than cold, I'm all in.
So, welcome to the Intellectual Property and Trade Nexus podcast. Welcome to the Intellectual Property and Trade Nexus podcast. Intellectual Property Nexus podcast. Welcome. Intellectual Property Nexus podcast. Welcome. We are glad to have you with us today. Today we will be moving into the intellectual property competition and antitrust case law. So we are going to be reviewing cases that the competition authority or the antitrust authority, either the regulator or from the agency, or case laws, looking specifically at cases that were dealt with in the courts or through the anti-competition, the antitrust commission, or through the competition agency. So we are basically going to be reviewing competition and antitrust cases that interface with intellectual property rights. So thank you for joining us. Thank you for having us also. You are welcome. We are going to take a brief interlude of music before beginning this episode. Today happens to be the 9th episode, and we have 2 episodes for the case law on competition antitrust. And so today will be the first episode on the case law. We'll have another episode hopefully next week. And so let's just take a brief interlude of music before we begin, because this will be a brief.
Load up the dice, so heavy. The way that you roll, I'm falling. So I never fall. I'm ready to take my chances, to take my time, to keep on dancing, to walk that line, yeah. You got me shifting, the paradigm. No longer wishing. You're my lucky strike. Love the way you ride. Look into my eyes, and you're ready to go. $1 billion life, we can roll the dice. Act like you surprised, but you already know. You're my lucky strike, and I got to tell you, if you didn't know, then I got to tell you that you're my lucky strike, and I got to tell you, if you didn't know, then I got to tell you that you're my lucky strike. I know that you think it's so important to.
So without much ado, we'd like to move straight into our IP competition and antitrust case law. Like I said, wherever you are following us from, good evening, good afternoon, good day, good morning. Today episode we focus strictly on competition and antitrust case law that interface with intellectual property protection. So we are strictly going to be reviewing case law or cases that were dealt with by the courts or the competition agency as a regulator or the antitrust agency, depending on the country, whether they're in the US or the European Union or Canada or any country that has a competition authority or an antitrust agency. So specifically, we will be beginning with the AstraZeneca and the European Commission case. But before moving to that, I would like to emphasize that most of the cases are with regards to anti-competitive practices that are being exhibited by companies are mostly within the pharmaceutical sector. So in the pharmaceutical industries and markets, there are a lot of complex cases that are dealt with basically because the pharmaceutical industry is not or the pharmaceutical market is not a regular market like petroleum or like grains, like the smartphone industry. They are very complex in nature. There are a lot of regulatory aspects of the cases that might be somehow complicated to address. So most often, companies that have cases of such nature, they might prefer to use the court, or in most instances, they would prefer to go to the competition authority because it is well known that the competition authority speedily investigate these cases within much shorter period as compared to it going to the courts. So the pharmaceutical industry is a very complex and industry is a very complex market in that sense. So there was a case between AstraZeneca and the European Commission. So AstraZeneca in this identical case basically provided false information to the European regulators within specific countries that they were manufacturing and producing drugs. So they provided false information to the European regulators to get an extension on their patent right. So after the patent right was supposed, in the event where the patent rights was supposed to expire, they went to the European Commission and provided false information for the requesting the European Union to basically extend the patent right on specific drugs within the market. So the European Union did extended their patent right within for several years, but later on, after some investigation, the European Commission found out that the information that AstraZeneca provided to them for the request of the extension of the patent right on specific drugs, those information were false and they were basically done to give AstraZeneca a competitive advantage on the market for a number of years. So when the European Commission discovered this, that AstraZeneca, the information, the representation they made in the request for the extension of their patent rights that those informations were false and misleading in nature, it then made a determination that that the information and that request for all those years that AstraZeneca benefited from that extension, that those information was false and misleading in nature. So it is sort of a very straightforward case in nature. AstraZeneca went to the European Commission. They made a request for extension of their patent, and based on that, they provided false information. And the European Union, after the European Union also, the European Commission went ahead and granted the extension of their patent, but is later on discovered that the information provided was false and misleading. So it's a very one would think that it's a very straightforward case, so that the European Union would just move, maybe fine AstraZeneca, revoke their rights, and in that case, and the case is done. Anyone will expect that would be the outcome of that case, since AstraZeneca provided false information to obtain a patent extension. They should be fined for that, and the patent rights should be revoked. End of the case. But that was not the case in this instant. The case was taken to the competition authority, and it was within their purview to investigate and come out with a decision. So there were several reasons why the case was investigated and placed in the purview of the competition authority. One is that the regulator take a longer time to finalize a case. So they spend the European Commission, that happens to be the regulator in this case, they spend much longer time to investigate a case of such nature. So they could take 5, 10 to 15 years to investigate this case. So that could be a longer period. And so it was not going to be beneficial for the both parties in the case, be it the European Commission and that of AstraZeneca, if the case would take longer period to be investigated. And the second reason is that the regulator is considered too close to the industry. So there's a consideration that they will not be impartial. So the regulators, the European Commission, they work closely with all these companies engaged in competition and antitrust protection. So because of their closeness to these companies, it is considered that if the case is placed in their purview, they will not be impartial as a regulator. And the third reason going forward, is that the competition agency investigates and conclude a case much faster with a decision. So instead of going to the regulator, the European Commission in this case, they chose to go to the competition agency, because the competition agency investigate cases of such nature, anti-competitive practices or unfair competition cases are investigated much faster by the competition agency. So they investigate maybe within a year or two and make a decision on the outcome of the case, as opposed to the regulator, which happens to be the European Commission in this case. It might take 5 to 10 years. And considering the position as a regulator in the sector, they tend to be closer to the industries within this market, and there's decision by others, maybe civil society and other outsiders, may be considered impartial in this instant. So that is the AstraZeneca and the European Commission case. So providing false and misleading information as a means to gain competitive advantage on a given market. In a case is the European market. AstraZeneca was engaged in anti-competitive practices, providing false and misleading information to gain competitive advantage on the market. So that concludes for, and it also shows how advantageous it might be for a given company to use the competition agency rather than using the competition regulator. Because in this sector, be it antitrust or competition enforcement and protection, there are two bodies. We have the regulators that regulate the sector, then we have the competition agency that ensures and investigate and make decisions on cases that are filed to them. So this concludes the AstraZeneca and the European Commission case. Then we move to the South African case. The South African case took place in 2000, where HIV/AIDS was very prevalent in South Africa. It was a big problem for the country, and the South African government had failed from 1999 up to the 2000. The South African government failed to address the issue of the high rate of HIV's positive within the country. So because of this failure to tackle and address the HIV and AIDS crisis within South Africa, it is a fact that 25% of all of government employees were HIV positive back then, from the 90s to the 2000s, within that period when South Africa was facing an HIV crisis. An amount of 25% of government employees were HIV positive. So the scale and the magnitude, the impact of the HIV crisis in South Africa was very disastrous. So it was a national and an international emergency for South Africa to address HIV crisis, and even the international world had to move to South Africa AIDS, because it was very detrimental for South Africa and other African countries, and countries in Asia was also faced with high amount of HIV patients within their country. So, but the South African case was the most talked about, the most prevalent, and the most critical in that sense. So the South African companies due to all of this impact and the level of death, the level of HIV infection, decided to make a request for lessons to the major producers of the HIV drugs. So basically, the drugs were a mixture or cocktail of several combinations of HIV drugs that were very effective in addressing the disease and in managing the disease. So South Africa made that request to the companies that were the major producers, Lasso and Bongo, that we need a license to be able to produce the drugs and sell the drugs in South Africa and possibly to other African countries that were in need of the drugs. So it's a request in a period of emergency. South African companies thought it was prudent to move quickly to request for a lesson from the major producers of these HIV drugs or cocktail or several combination of HIV drugs. So the major producer being Lasso and Bondo denied the request of the South African companies and decided to continue to sell the drug at its regular international price, which happens to be very expensive and exorbitant for South Africans, poor South Africans, and ordinary citizens that were infected with the HIV drugs. So the case was taken to the South African Competition Tribunal to be investigated. So it's an emergency. It's an emergency. People are dying from the disease, HIV and AIDS. There are a lot of people infected within the population, and these people cannot afford the original price by the major producers of the drugs, and the local companies made a request to be lessened by the major producer to be able to sell the drug locally in South Africa and in other parts of Africa. Their requests were denied. So they took the case to the South African Competition Tribunal to be investigated. So basically, after that was done, due to the nature of the case, it's a national emergency. It's all in the news. There's the political aspect of it. So the whole world in general were moved by the case, and there were a lot of interventions being made. South Africa happened to be a member back then of the World Trade Organization, so intervention being made from the WTO by the South African government, discussion being held with the major drug producer. So there were a lot of engagement. It was a global news, and it was a national crisis for South Africa, but it was a global crisis that they never wanted to viral to spread all parts of Africa and maybe globally. So it was an international case. And so due to the nature of this South African HIV crisis, the local companies and the major producer of the HIV drugs, the case to the South African Competition Tribunal was investigated and the parties settled. So Lasso and Bongo decided to settle with the local companies in South Africa because they never wanted to. There were a lot of backlash on them about humanity, people dying. There was the social aspect, the economic aspect, the political aspect. So it was a very big case. So the company decided to settle, and the outcome of the settlement is what I want to discuss. The producers, Lasso and Bondo, decided to make available the HIV drugs at a lower price within South Africa to the local companies. That was the first outcome of the settlement. The second outcome is that the South African companies were allowed to produce the drugs locally and export them to some sub-Saharan African countries. So there were a lot of outcomes, but these were the two major outcomes of the case. Lasso and Bondo made available the drugs, the HIV drugs, at a lower price on the South African market, and they gave permission and allow the local South African companies to produce the drugs locally and have the possibility to export them to sub-Saharan African countries where other nations were facing, where other nations had HIV and AIDS patients, and they also needed the drugs. So the issue of excessive price is kind of difficult to prove. In this case, the international producer of the drugs never wanted to reduce, never wanted to give lesson to the local companies to produce the drug locally, but they maintain the same price. They continue to sell at a regular international price, and this was detrimental for most South Africans that were infected by the virus. They couldn't afford to buy the drugs. As a result of that, there were a lot of deaths in South Africa. So excessive prices are most difficult to prove in courts because it hinges on the concept of excessive profits. So in order to prove excessive price on a specific commodity, maybe a drug, an electronic product, or whatsoever product or commodity, to prove excessive price, you have to prove excessive profits, which can be difficult to prove in courts, to provide the necessary information and evidence in courts to prove this. Because it hinges on the concept of what excessive profits. So if you are in a given market and you are the sole, maybe the sole importer or the sole producer of a specific commodity, let's say you are the sole producer of smartphones on a given market, or you are the sole producer of malaria drugs on a given market, you are a monopoly. So you can engage in anti-competitive practices where you already are advantaged, but then the determination of the prices of that malaria drug then can be made by you. So you are a monopoly in this case. But on the contrast, in excessive prices, proving excessive prices, if there are existing companies, if there are existing competitors on the market, we have about 5 companies on the market producing smartphones or producing malaria drugs in this identical case, pharmaceutical case. So you have 5 companies producing malaria drugs on the market, on a given market. It is difficult to prove that they are one company is engaged in excessive price because the consumers have a choice to choose among 5 different companies. So if one company price is higher, you have the option of choosing from 4 other companies. So then the argument become very difficult to prove that this identical company is having an excessive price when there are other options. If the price is excessive, expensive, or the product, the drug is expensive, the malaria drug is expensive or exorbitant to you, you have the option to choose from 4 other companies. So you cannot say it's difficult to prove that this company is using excessive price when you have the option as a customer to buy the malaria drug from 4 different companies. So this is the difficulty in proving excessive price in a given market. So the theory of proving excessive price is difficult because it is a theory that in the absence of competition is easier to prove, but with the existence of competition and other alternatives for consumers to choose from, it becomes difficult, specifically to prove in quotes. But in practice, there are situations where excessive price do exist. There are situations, not so often, but there are certain situations where excessive price do exist. Even if you might have 3 companies and one is increasing or one has a higher pricing, there are possibilities that you might prove excessive price. So courtesy to Mr. Giovanni Napolitano, one of my lecturers during my master studies at the University of Turin. He made mention of this story in Italy. So there was an airline ticket company that had a case against it for excessive pricing. So within the airline operations, specifically within antitrust law, each route is a specific market within the airline industry. So in Italy, this airline company was charging for tickets from the south of Italy, to the north of Italy in Milan. So the first destination was from the south of Italy. The second destination, which is the north of Italy in Milan. And the third destination, which happens to be the final destination, the plane's lands in New York. So the actual ticket is from the south of Italy to the final destination of New York City. However, from the south of Italy to Milan is one route. Within antitrust law, one route is a specific market. So from the south of Milan to the north of Milan, that one specific market. From the north of Milan to New York is another specific market. But in the context of this airline company, their ticket was from the picking up spot of northern Italy to the destination spot of New York City. But however, travelers, some of us that always travel, and you always look for the most affordable ticket. I will not say cheap ticket, but the most affordable ticket, because you want to move with an airline company that is safe, that have the reputation of safety and perhaps good service, and there are no issues with them. So travelers opted to look for the easy path, to look for an affordable ticket, and this ticket, the identical ticket the airline company were offering from North Stream Milan to the destination of New York City, was a very cheap ticket, very affordable ticket in that sense. So travelers then decided that since the ticket moves from Northern Italy to Milan and New York City, I will buy this ticket and it's cheap and affordable enough for me. You buy the ticket, you leave from Northern Italy, you land in Milan, and you get off. So majority of the travelers that were reaching the destination, was traveling to Milan, decided to opt for this ticket because it was much cheaper and affordable. But the actual destination was not to go to New York City. The destination was to land in Milan and get off the plane. So the airline discovered this, and they decided to take some decision. And the decision the airline company took was that the decision the airline company took was that if you decide to purchase this identical ticket from the north of Milan, no, from the north of Italy, from the south of Italy to the north of Italy, Milan, and the final destination, New York City, you are not going to, if you purchase this ticket, you are not going to get down in Milan. You have to reach your final destination, New York. So the airline company was basically compelling travelers to either opt to buy another ticket that the final destination is from Southern Italy to Milan in the north. Or if your final destination is New York City, then you have the option to buy that ticket at a cheaper price. So that was the decision the airline company made to compel the travelers to pay for the ticket and not get off in Milan, but to reach the final destination of New York City. Then the obviously the travelers and those traveling on that identical flight will take offense to it, and so they file a complaint for excessive price. So basically, their argument was that the argument the travelers were making when they filed their complaint is that how is it that it was cheaper to go to New York than to go to Milan? You live in Italy. The ticket from southern Italy to New York City is cheaper as opposed to a ticket from southern Italy to Milan in the north, which is 1/10 of the full ticket destination. If you are taking it from southern Italy to New York City, stopping Milan is 1/10 of the total destination. So this is the argument we're making, that a ticket from Softstream Italy to New York City cannot be cheaper than a ticket from Softstream Italy to Milan in the north. So they went and lodged a complaint to the competition agency for excessive price. The airline company was using excessive price for travelers that are moving from South Stream to North Stream Italy, Milan City. So the case may seem like a straightforward case that is direct. Obviously, it's an excessive price because it doesn't make sense. There's no logical essence for a ticket from the south of Italy to New York to be cheaper from the south of Italy to the north of Italy. So it's just obvious that it might be excessive price. So that how any ordinary person would think. However, we need to take into account the cost of the company. So the cost in running a flight from Softstream Italy to New York City, that needs to be taken into consideration. And the second thing that needs to be taken into consideration is to compare the ticket price with the cost. The first, you must consider the cost of the airline company to have a flight from Softstream Milan to New York City. The second issue you must take into account is to do a comparison of the ticket price with that of the total cost of the airline company. Then the third thing you need to take into consideration before making a determination that the company is using an excessive price is that on this identical flight from Softstream Italy to Milan and to New York City, there were no other flights existing. No other flight companies chose this route to have other alternatives. So this was the only company that have flight for this specific destination. Softstream Italy, Northern Italy, New York City. They was the only airline company offering that. So you might, from the outside, you might look at the case and say, wow, this is a very straightforward case. The airline company is exercising an excessive price. They are using excessive price in this case. However, you have to critically take into account the cost of the company, compare the ticket price and the cost, and see if there are other alternatives that travelers could use aside from this airline. So if there are several other airlines, maybe 3 or 4 airlines that are using the same route, then that could be also taken into consideration. But within this, on the contrary, this specific case, the airline company was the only company that offered flights within a specific destination area. So basically, what the airline company was doing was extracting the maximum profit from the customers. The maximum profit the customers were willing to pay for this specific route because there were no alternatives. Other companies were not providing flights for this identical route. Softstream Italy, Northern Italy, New York City. There were no other company providing flights within this identical route. So the company chose to what? Extract the maximum profit from this identical route that the customers were, they said, willing to pay. However, most of them were not willing to pay in the end, because that's why they filed a complaint. So basically, this is what we refer to as, in economics, perfect discrimination. So in economics, we refer to this as perfect discrimination, as an economic concept, because the airline company were extracting the maximum profit from customers because of the circumstances surrounding this identical flight route. So in the end, the decision that was made by the competition authority was to close the case due to insufficient information. The competition authority said that we don't have sufficient information because there were a lot of issues involved, the amount of cost that the airline company was using to have their planes using this route, the ticket price they were offering, making a comparative analysis to the cost. They were the only provider of flight on this route. And so there are a lot of things you needed to take into account. So the competition authority said within a specific case, they were not in the position to make a determination because the information available to them was insufficient. So that's how this identical case ended. So 35% profit, can we consider that as excessive? The amount of profit the airline company was extracting from this. So it's a philosophical question. Is 35% profit margin from a specific route considered excessive price? This is the philosophical question. So to conclude, in the South African HIV case, a lot of people were citizens and inhabitants of the country were infected, and the total amount for the if you were a patient, the total amount you needed was 12,000 United States dollars on an annual basis for the cost of the drugs, and the average income was 2,600 United States dollars. So look at, if you compare and contrast, you will see the differences in what an individual needed as an annual cost to buy the drugs, and the average income within that economy was 2,600, and the annual cost to buy the drugs was 12 United States dollars. So obviously, most of the citizens could not afford the drugs. Those infected by the drugs could not afford it. So as a result, a lot of lives were lost in the process. But in the end, the company, the producer of the drugs, Lasso and Bondo, decided to allow the South African companies to produce the drugs locally and allow them to export it within other sub-Saharan African countries. So basically, this is how it went on for the South African case. And that to stress again that to prove excessive price most often is difficult because there are a lot of complexity and intricacies that is attached with the case, whether you want to take it from the regulatory aspect or the anti-competitive practices that are being considered. on a given case. So if you choose to use the route of adjudicating or litigating that case within the court system, you must be prepared to provide sufficient. Because if they will, like in this air flight ticket case, if the information or the evidence provided is not sufficient enough, a decision will not be made in your favor. So whenever you decide to use that route, you must make sure that you have all the evidence and it should be sufficient enough to render the case in your favor. It should be beyond all reasonable doubt. So let's move forward to sham litigation. Sham litigation. So sham litigation are cases wherein you have as a business, as a company, as a citizen, you have the right to move to a court to protect your right, be it in business, be it your fundamental human rights. So constitutionally, in most countries, the constitution allows for a citizen to sue or to be sued. So it's a constitution and fundamental right of a given company to sue or to be sued. So within the sham litigation cases, specifically a United States company, a U.S. company, La Lili launched series of lawsuits and cases with the competition authority to prevent its competitor from selling other drugs treat cancer. So La Lili happens to be a United States company that use the court system to prevent its competitor from selling drugs, cancer, specifically cancer treatment drugs. So there are instances where a drug could be produced to treat a specific disease. Say this drug is produced to treat malaria. Okay, the drug is produced to treat malaria, but then over time, researchers made a lot of research and identify that due to some active principles, ingredients within that drugs, it shows that the drugs can be used to treat other diseases. And other diseases that were not originally or initially mentioned in the patent claims. So La Lila happens to be a United States company that was producing cancer drugs and selling it globally. But then after it discovered that some of its but before moving to that, the specifics of the case, like I said, There are often terms or drugs may be produced to treat specific disease or diseases. But then over time, researchers or people that have used the drugs, doctors and those in that specific working with that specific disease can identify that certain elements, certain ingredients of that drugs can also treat other diseases that were not originally considered when the patent claims were being made. So you might have to, when you discover and you identify that this drug are initially produced to treat malaria, can now treat cancer, can treat uh, maybe kidney disease or some other diseases, you have the opportunity to make that case and provide the necessary evidences to substantiate your claim, maybe to the patent office or to the courts. So this was specifically unique to this case. So La Lila was trying to protect itself from competition by launching lawsuits to prevent other competitors within a global market, but specifically within certain countries from producing drugs that will address diseases that for drugs they had in their possession. So they went to the regulator, they filed a case against their competitors that all these companies they are producing drugs, on the market that does not fit their patent claim. But basically, the case they presented to the regulator, they were not fair enough. They provided information that was deemed to be false and misleading as well. So they provided false and misleading information to the regulator through sham litigation so that the regulator could step in and prevent their competitors from producing certain drugs on the market. So after a full investigation into the case, the regulator then made a decision and said that the company provided false and misleading information in order to prevent their competitors from having access to the market, and so they were engaged in anti-competitive practices. The second outcome of the decision from the regulator was that they also intended to widen the scope of their original patent in order to deter competition. So they investigated the case and also found out, aside from the false and misleading information the company provided to prevent competitors on the market from having access by producing and selling certain drugs on the market, they also made attempted to widen the scope of the original patent in order to deter competition on the market. So, in conclusion, La Lady was charged and fined for excessive prices and for filing a lawsuit based on false information. So that's how this identical case was concluded. So the competition agency, the antitrust regulators. So these two institutions or entities play a very critical role in mitigating unfair business practices and anti-competitive behavior on the market. And as a result, consumers and users stand to benefit from a very competitive market system. There are a lot of options to choose from. The quality of the services being provided on the market are very encouraging because companies or those competing within a specific sector, be it in the pharmaceutical industry or be it on the smartphone market, they don't want to lose their clients. They don't want to lose customers. So in order to maintain your customer base, in order to have a sustainable market, a sustainable market share or an increasing market share, you need to provide quality customer service, whether through service center or through the quality of the product you provide on the market or the quality of the services you provide. Because if you fall short of providing high quality products, good quality services, being able to engage your customer and address and resolve their needs, you will lose those customers to other competitors on the market. So this makes it competition ensure that a given economy is thriving, that the market is very conducive, open, and that consumers then stand to benefit more for their money worth. And also, companies engage in providing products and services on the market and in return get the necessary profit, not to engage in profiteering, but to get the necessary profit margin from the products and services they render to consumers on the market. So that's how critical it is to have a competition agency, to have an antitrust regulator on the market, whether it be an agency or a regulator within a given market. You need to have this institution to counterbalance the effects of anti-competitive practices, unfair and unethical business behaviors, and unfair competition on the market. Because in the end, your economy will be very attractive. You have a lot of companies on the market. You have a lot of startups engaged in innovative venture, engaging and attacking technology from a different perspective, from a niche perspective, from an area of from an area that we haven't even imagined, but there are startups engaged in addressing those needs for customers, consumers, and for the general public in a whole. So it is critical. I must overemphasize this, that it's very critical to have a competition agency, to have a regulator within a given economy to ensure, and not only having them, but ensure that they are working, they are performing up to the tax, and they are meeting the demands for why they were established as a regulator or a competition agency. So this is what we will this is what I wanted to cover for now. I think roughly an hour. So we will be doing another episode. Today we just concluded with sham litigation, but we have other cases to follow through. So I will do another episode, maybe briefly, maybe tomorrow, day after tomorrow, or anytime next week, to cover all sufficient case law of competition, antitrust cases that are intellectual property related. So thanks for following. Ask that you leave your questions, your comments. Like I say again, heartfelt CC greetings to all of our supporters, our followers, monitor us on a daily basis. We tap a new approach in the new year because we want to look deep into technology. So we'll be looking at new and emerging technologies. We will be looking at basically Tesla vehicles. We'll be looking at drones, but we want to have a physical feature of the podcast where we have guests inviting other guests. I've invited several of my colleagues, so hopefully within the new year they'll be able to come. But we want to adapt other topics, topics that are related to technology, to new and emerging technologies. We want to look at the latest development in innovation. What are the robotics innovation being made in Japan? Japan is well known for robotics. So we go to companies engaged in robotics innovation. We will do a video where you will see the company, you will see the products they are engaging. We will go to Tesla, you see the vehicles, the Tesla vehicles, you will see the truck, you see the specifications, where they are engaged, what the services and products. And we'll move to maybe an update. We have a section where we have an update from the World Trade Organization, the World Intellectual Property Organization. What are the decisions being made, and how could those decisions affect the global economy? How those decisions could affect international trade? How their decisions from wide pool could affect intellectual property administration or international trade governance. So we have some new topics, some new approach following in the next year. So we want to close by saying heartfelt season greetings from the RP and Trade NEXUS podcast to you and yours. Thank you for having us. Close on this note. Basically,
convince everyone else that you're not boring, but it's making me feel like my skin is crawling. I keep pouring out my empathy to someone I don't even see eye to eye with. I don't mind if you don't have it all together. Yeah, I get it, we're all human, but I give you an inch and you take miles. It's tragic, ruining my sanity with tales of animosity. I'd rather cry than let you drive me crazy, lose my mind, and I swear I might die if I cared more, but you're not worth the time. You never put me up front, cause it's your spotlight. I'm in the backseat of my own car. I'd rather cry than let you drive me crazy one more night. Climbing up somebody else's ladder just to make yourself feel just a little bigger. I don't know if I've seen anything that's
okay, guys, bye. Thanks for having us. We see you soon on the next podcast. Bye.